opening the floor for questions, I would like to sum up the 5 papers that we had. In fact, there were 5 interesting papers on 5 different aspects of contract law, and I must thank them. I must express my gratitude for enlightening us on these aspects. And I'm sure that this will serve as an eye-opener, and it will generate a discussion and debate on the need for law reform. Because law is not a static thing, it's a dynamic thing. It should change to suit the modern context. Some of the laws that have been passed, as the last speaker said, are very old, so they need to be reformed. So therefore I think symposia of this nature will serve that purpose. Now, for example, Mr. Sarveswaran, senior lecturer attached to the law faculty of the University of Colombo, made an excellent presentation on the duties and powers of industrial arbitrators. He made the point that industrial law, although the relationship between master and servant or the employer and employee is a contractual one, it is different from other contracts. So therefore the law has recognized the need to provide protection and an easier and less costly mechanism for enforcing their rights. So therefore I think he has done a good job and research, and I congratulate him for his paper. And Mr. Sumanadasa dealt with Roman Dutch law and English law, how they apply to contracts in Sri Lanka. Although Roman Dutch law is a common law, most of the commercial contracts are governed by the English law. As you know, it was introduced during the British period by a number of ways. The English trained judges, even without their knowledge, applied, instead of Roman Dutch law, they applied English law. And statutes like the Civil Law Ordinance of 1852 imported English law. Like that, English law also has been incorporated into our legal system. And Dr. Yenage stressed the importance of having a government-sponsored institutional and legal framework for the resolution of international commercial disputes. I think it's very important because some of these mechanisms that are available are not in favor of developing countries like Sri Lanka. So therefore, we must have our own mechanism to suit our conditions. Some of the, for example, even in the field of intellectual property law, some of the mechanisms are not in favor of major importers. They are in favor of exporters like developed countries. Now Sri Lanka is an importer of, for example, copyright works. So therefore, it is not in our interest to depend entirely on the existing system. So therefore, I think it's timely that we have a system that suits Sri Lanka. Then the 4th paper on recognizing and respecting the rules of the game is another interesting paper presented by Ms. Gajadira, and I think it provided food for thought, especially for young law students like you. So it's, I think it provided food for thought. So you must think about it and come out with your own views and generate a debate. And lastly, Ms. Helen Menaka presented an interesting paper on the property rights of women under the Sri Lankan legal perspective. So I think they were able to enlighten you. They shared their experiences by expressing their views, and they shared their experiences, and therefore I congratulate all of them for the excellent papers they presented. And now I open the floor for questions.
Industrial application is more developed, but civil application also is there. But that's why I think now industrial application, other than that, now you see basically labor tribunal. You go to labor tribunal and what? Always the president support go for settlement, go for settlement, go for settlement. So likewise, employer federation is always specialized. I have my own personal experience. So in that case, I think rather than in this industrial commercial application is very street cooperation. Because of that only go and do but the culture is totally different. And honorable sir, and they are moving from outside. So that culture also now developing. They are not ready for long period of complexity. But I think IoT and civil application also there is a trend of it. Now industrial application also starting out to these are all retired architecture and you also notice you go to labor department 7th floor, labor welfare, and you can see that 10 people are coming. So therefore I mean other than the trade unions, they have a good investment. So I think this application we must idea on that. And also recognition is very very important. Now one thing in a maritime application, Sri Lanka now they are and also we insert a lot more. I don't know trade unions started they had some arbitration center groups also.
Thank you, Dr. Maheva. Are there any other questions on any of those articles, papers?
And the other thing is, I saw that this same paper was produced by NGO who at the National Action Plan. Dr. Mahana Maheva also will support. I think they are considering, but the line ministry is land ministry. They said that this is against our common law system. We have a very good, reasonable succession law. Therefore, there is no need at this time, at this juncture, to amend this land development regulation or the act. That's what that I experienced.
May I also add a point to what you said? Even our common law, Roman Dutch law provides, principles to support, married women. Then this applies even to those in north and east. Now, for example, there's a decided case of Lalchan versus Saronamuttu, where the Roman Dutch law treats the married woman as the manageress of the common household. So as long as there is a common household, she has the power to pledge the credit of the husband. So she can buy things on credit and the husband is bound to, pay. So she can make use of that as well. So there's provision in the Roman Dutch law also, unlike English law. Under English law, the married woman is treated as an agent. So the disadvantage for English married women is that if they fall out, the the husband can revoke that power. Whereas under the Roman Dutch law, it's by virtue of law, by operation of law. So therefore the husband cannot deprive her of that right under the Roman Dutch law. So Sri Lankan married women are in a better position than married women in England, governed by the English law. So that provision is also there. And under the married women's property ordinance, they have been given a lot of freedom also. Now they are treated as semi-sole. Although they are married, they are treated as if they are not married. So there are, things to think about also. Right.
2011-2016. In that, paper presented and this issue came up in a national letter. That's all.
Yes, that's right. Thank you. Thank you for making that point. Yes, I think these. There's time for one more question. Please make use of this time. Time is precious. So please, if you have any questions, you are free to ask any question. Any question? They're tired. They've had presentations.
Thank you, sir, and thank you, everyone. Now I would like to invite our session chair, Dr. Redrigu, to give away the certificates to the presenters. Firstly, I would like to invite Mr. A. Sarveswaran, Mr. W. A. D. J. Sumanadasa, Dr. K. Chintaka Liyanage, Ms. Amasara Gajadira, Ms. Helen Menaka. Thank you, sir. Now I cordially invite Dr. Pratibha Mahanamaheva, Dean, Faculty of Law, to present a token of appreciation to our session chair, Dr. Redrigu. Thank you very much, sir. Thank you, sirs. As we have reached the conclusion of today's events, I would like to thank you all for your participation and support. And I also invite you all to join with us for tea in the lobby area in the 5th floor. And before I finish or wrap up the session, I say this, I hope to see you all again next year in a session like this, which will be enriched by more interesting presentations, and I hope to see you all there as well. Thank you very much for everything.